5 seconds to go. Start. To constitute even an accusation of criminal conspiracy, first and foremost, there must at least be an accusation of meeting of minds of two or more persons for doing an illegal act or an act which is not illegal in itself by illegal means. In Ajay Agarwal versus Union of India and others, this court characterized the offence of criminal conspiracy as an agreement between two or more persons to do an illegal act or illegal through illegal means. Furthermore, it was held that commission of the offence would be complete as soon as there is consensus ad idem, and it would be immaterial whether or not the offence is actually committed. It is also held therein that necessarily there must be agreement between the conspirators on the design or object of the conspiracy. As held in R. Venkata Krishnan case supra, the quintessential ingredient to attract the offence of criminal conspiracy is agreement between two or more persons. Therefore, the question is whether it spelt in the final report dated 21st February 2000 or in any of the records of the case and documents submitted therewith so as to find a prima facie case of commission of criminal conspiracy against the appellant. True that an agreement referred to in section 120A IPC may be expressed or implied or in part express and in part implied. However, no record of the case or documents submitted therewith carry such an allegation accusation against the appellant. What is the common plan or the common intention? This aspect is also conspicuously absent in the materials produced by the prosecution. In regard to all such aspects referred above, none of the witnesses has spoken while giving statements under section 161 CRPC. In this context, it is also to be noted that according to the trial court, a very strong suspicion lingers on account of twin circumstances. In the order dated 19th April 2007, the trial court in this regard observed and held thus. The learned Assistant District Government Counsel Criminal has argued that if the accused person says that he had fell ill in the night and he was complaining of having pain in the chest, then why his family members were not informed? The said condition is also very much suspicious. Besides these, the accused was handed over to the police by the accused Ram Prakash Chadha himself, and in the next day morning, the report was lodged by him only. Keeping in view the above mentioned entire facts and circumstances, sufficient evidences are available on the record for the framing of charge against the accused persons Rameshwar Dyal Pathak and Jawahar Lal and Ram Prakash Chadha. In the light of the records of the case and the documents submitted therewith, it can only be found that the said finding of the trial court on the ground to proceed against the appellant is based on suppositions and suspicions having no foundational support from the materials produced by the prosecution. With respect to the first part of the above extracted recital from the order of the trial court, it is to be noted that it is nobody's case that the appellant was in the police station or informed of the sufferance from chest pain. As relates the second suspicion, it is to be noted that the very trial court itself, in the very order dated 19th April 2007 itself, stated that in crime number 351 of 1993 under section 392 IPC, the deceased Ram Kishore was only a witness and that the amount in cash and the draft involved was that of the appellant. Stop.